I'm Cheryl. I'm the administrator of CBM Lawyers. I'm here with lawyer Doug Simpson, who is also the leader of our family law practice group. Today, we're going to be discussing myths about parenting in a divorce. Doug, let's get right to it. What's the first myth?
Cheryl, the first myth is that in a divorce, the mother will automatically become the primary caregiver. Now, that's certainly not an assumption made in the law today. Historically, it's been common in relationships that one party serves as the primary caregiver, typically the mother, and the other party, typically the father, serves as the primary wage earner, what's often described as a traditional marriage. In the past, and particularly when the child was quite young, it was not uncommon for the mother to remain the primary caregiver. Today, marriages of this type are increasingly less common, and courts now make parenting decisions without any preconceived ideas about who in a relationship is best suited to care for children or what sort of arrangement is in the best interest of children. There is a provision in the Divorce Act which states that in making custody orders, a court must give effect to the principle that a child should have as much contact with each spouse as is consistent with the best interest of the child. Under the Family Law Act, the best interest of the child is the only consideration. Regardless of which piece of legislation you're under, the best interest of the child is the governing consideration.
I've also heard it suggested that the courts prefer a 50-50 parenting split. Is that true?
Well, barring some serious disqualifying consideration, it's generally believed by the courts that it's in the best interest of a child to have a relationship with both parents. It has been my experience that courts will in most instances look to achieve a form of co-parenting which works best for a child in any given case. By co-parenting, I mean an arrangement whereby both parents are exercising the responsibilities of parenting that are most conducive to the best interests of a child. But that doesn't always mean 50-50 time, nor does it necessarily mean shared parenting, which is anything from 40% of one's time with the child and up. Again, it depends on the circumstances and the best interest of the child. I recall a case where a father wanted to have the child for 50% of the time, but his job took him away from home and out on the road for significant stretches of time. He wanted his 50% parenting time, but wanted his girlfriend to look after his child when he was gone for significant stretches of time. The judge in that particular case did not feel a 50-50 arrangement was in the child's best interest. A judge will look at the obvious strengths and weaknesses of each parent. They'll also look at what has been the norm up to that point and the bond that exists between a child and each parent. But take note, just because someone hasn't been a primary caregiver in the past doesn't mean they can't be an equal parent or that a judge won't give them a chance to be so. The bottom line is don't make assumptions, keep a flexible frame of mind, and try to look at the best interests of your children from an objective perspective. At the end of the day, the courts don't really care what you or your spouse think is in your child's best interest. They only care about what is in their best interests.
What about co-parenting very young children? For example, I'm particularly thinking about overnight stays for children who might still be nursing.
Well, there's certainly a myth out there that very young children should not be doing overnights, but there's really no compelling authority for that in research or the law. For nursing newborns, I think the courts would agree that it makes the most sense for the child to stay close with their mother and keep overnights as something to work towards. But I've seen judges rule that children closer to weaning, say at the 18-month mark or so, should be able to go for an overnight to their dads. To say that my 3-year-old is afraid to stay overnight outside of their bedroom is not a sufficient argument. The judge might look at whether or not that feeling is being instilled in the child or if there are any ways to address the concerns raised so as to facilitate the visit. Also, children will always pick what's familiar over what is unfamiliar, so some reluctance on the part of a child is not unexpected. Absent some reaction on the part of a child which is indicative of serious attachment issues warranting investigation, or some other disqualifying factor on the part of a parent, the courts will expect parents to facilitate frequent, at first short, and then ever-increasing parenting time with young children, even if that means helping a child to get used to a new bedroom in unfamiliar surroundings.
that deals with very young children. Now let's consider other kids. Is it true that an older child, say a 12-year-old, can decide where they want to live?
That's a really common myth, and no, it's not true. It's true that according to the Family Law Act, the court is required to take the views of the child into consideration where appropriate. But there's no magic age at which the issue is placed firmly in the hands of a child in unqualified fashion. The degree of deference one shows to the views of children really depends upon their age, maturity level, and the implications of the decision they are being asked to make. However, from a purely practical perspective, judges are cognizant that as children get older, and most notably as they enter their teen years, their views become more and more weighty a consideration. The last thing a judge wants to do is push a child to the point of rebellion, or put so little stock in the firmly held views of a thoughtful, sufficiently mature child that they impose a thoroughly unpleasant situation upon them. However, in cases where a child harbors unexpectedly negative views about living with one parent, or there's so obviously a case of estrangement between parent and child, a judge may order an expert assessment of the situation or direct the parties and the child to participate in some appropriate counseling before necessarily giving any weight to the child's views.
Okay, speaking of children and the aging process, what happens if a situation changes? Such as when the child gets older and the original court order agreement needs to be modified?
Well, court orders are not etched in stone. Parties can always apply to vary an order on grounds that there has been a material change in circumstances. The question is, what constitutes material change? In other words, when is a change of the sort that would warrant a revisitation of the existing parenting arrangements? I've had clients who are concerned that their ex is repartnering or remarrying, and they don't like the new partner or spouse. Unfortunately, that isn't grounds for a change to an order. The exception is if the child comes under threat from this new party. For example, if the couple are frequently fighting and there is the threat of family violence, or if the new partner or spouse is known for drugs or gang activity, these would likely be valid grounds for a change in order. Another reason would be when there has been a significant health change in one of the parents. For example, in cases of addiction relapse or dealing with a major illness, one of the parents may no longer be in a position to provide a safe and healthy environment for the children. Another example might be the order is basically out of date due to the passage of time, such that it no longer bears any relation to the current reality for the child and his or her parents. As children get older, an order that may have made sense when the child was, say, 7 years old will likely not have as much meaning to the situation that exists when the child is, say, 14. There are really no limits to the sort of circumstances that might create a material change. What is common to all such changes is that they represent a change that was not readily foreseeable at the time of the original order, and which would have resulted in a different order being made had the facts as they stand now been before the judge in the past.
How long does it take to get these changes made?
Well, parties can make changes by consent any time they like and with little effort. However, if the matter is contested between the parties, with the notice requirement for changes to final orders, it will at least take a couple of months for a hearing, and possibly more depending on the magnitude of the change. However, if the child is at risk of harm due to a change in circumstances, there are usually interim measures that can be taken more quickly to temporarily address the situation.
Does every change to a parenting agreement have to be done through the courts?
Good question, and the quick answer is no. I've often seen instances where as children age, the parents work together to make appropriate adjustments to the co-parenting terms. For example, a teenager might want to spend some time on the weekend with friends, so the parents might adjust the visitation that was to take place then to another time. A formal order change by the courts is really only necessary when the parents don't agree on the change being proposed. In essence, they are saying, we can't agree, so we ask the courts to make the decision for us.
So what should parents do if they need to create a co-parenting arrangement or are concerned about the one that is in place?
Well, initially, they should work with a lawyer on a co-parenting arrangement as part of the separation and divorce process. These are very important decisions, and we strongly recommend getting the appropriate legal advice before entering into such an agreement or pursuing a particular course of action. If changes are needed to that arrangement over time, we again strongly recommend that they get legal advice before agreeing to any changes or taking steps in court to pursue changes. These are all matters in which any member of the Family Law Department at CBM Lawyers would be happy and fully able to assist with.
Thanks, Doug. For more information on this and other family law issues, or to learn more about our family law practice, go to www.cbmlawyers.com.